to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone will have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it is usually based upon a percentage of the bond. Finally, if you use property to post a bond, the property will need to have a net equity at least 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise your right hand. Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God?
Yes, I do.
Okay, let's begin with Mr. Jordan Parrish.
Come up here. Your Honor, Mr. Parrish.
Okay, Mr. Parrish, I would normally speak to you directly. However, you have hired an attorney, Mr. Edie, who's here. So I'm going to speak to Mr. Edie about your case. You should understand that anything you say here is not private. It can be heard by everyone. So please don't say anything that you don't want the whole world to hear, okay?
Gotcha. Yes, sir.
Mr. Edie, your client, Mr. Parrish, is charged with 1 count of battery. I preliminarily set the bond at $5,000. I placed a stay away provision on the bond to stay away from an Amici Clements Hill. He has a preliminary hearing date that's going to be set for June 21st at 8:30 in the morning, but that date will get waived upon his bonding out. I will listen to you, sir, as to anything you want to tell me as it relates to your client or to bond.
Okay, Judge, appreciate it and good morning.
Good morning.
I just appreciate you more than likely for the gracious amount for the bond. I just would make my argument clearly for that purpose. Mr. Parrish, he's a newly hired at a Fresh Point Warehouse as a package handler, and he's in that 30-day gap in which he has that attendance that needs to be reconciled and looked at very closely before he's bringing on full time. So yesterday he was picked up obviously in the morning right before work, so that will put him at a precision of one absence. So he has limited help in which he's basically covering this case itself. So what I'm asking for is I'm assuming that we have looked at his background. It has little to no background with nothing on a violent history, and that if this could be dropped down from a $5,000 bond to a signature bond, that way he can get back to work today. I'm just a little afraid that if it's something that he couldn't make right now, that he could possibly run into missing, work today, tomorrow, and then possibly being subjectively being released, and then at that point have no work. And we know that due to COVID, a lot of job opportunities are very scarce. So I just want to put him in the best position to continue to succeed at his job, and that we are grateful for the $5,000 bond, but signature bond would definitely help. And I could assure that basically looking at the Ayala factors, that he would be a great candidate for this bond.
So the procedure that we have in place currently as it relates to signature bonds is that he would have to stay in jail another night while I review his case with my chief, because she's the only person that can approve a signature bond. So I would have to continue his case over to tomorrow, meet with my chief this evening about everyone that makes the request. If they want to do it, we meet in the evenings to discuss it. And then
But,
she makes the final determination, and I come back the next day.
well, can I be an alternative? I believe that a $2,500 bond would be something that I believe he can make today with a little help, if that can be considered today to try to get him out today.
So I'll tell you this. One of the concerns I have as it relates to battery, simple battery, simple assault, all of those kinds of cases is, although these are allegations, it's kind of a thing where, people can get lied on, but I can make the decision not to put my hands on someone. And if I don't do that, I'm never in the position of having to have this discussion. And I know at this stage that he's presumed innocent. And so just so you understand, as it relates to bond, I take the fact that he's completely innocent, and I take the fact that he did what they said he did. And then I have to decide what is the appropriate bond based upon both of those factors, whether he's completely innocent or whether he did what he said they said he did. So that's where it's like, oh, you did this, you're going to jail. I'm not going to let you out. That's on the side of he's completely innocent. On the side that he did what they said he did, if he did it, what is the appropriate amount of bond to be set in that scenario? So I am comfortable with the $5,000 bond. I'm scrolling through to get to his criminal history, because I do review them as I go through each case, but it's like 300 pages of stuff, and I, of course, can't commit that to memory. Okay.
From my understanding, it should be just a misdemeanor possession back in high school of marijuana, and I believe that he just paid the fine probation. If I'm not mistaken, I believe it could have been expunged, but if not, that is my understanding of his background.
Let me look. Let's see. Yes, there was a misdemeanor possession out of Cobb back in 2017. And the failure to appear related to that same incident. What I'll do, Mr. Edie, is I'll reduce it to $3,000.
All right, I appreciate it, Judge.
Mr. Parrish, do you understand the stay away provision on this bond, to stay away from a Mishi Clements Hill?
Yes.
Okay, and so what I've taken into account is your lawyer's argument and the fact that this warrant has been pending for more than a year. And it doesn't appear from your criminal history that you've gotten yourself into any more trouble. So I'm willing to reduce this down. Is there anything else, Mr. Edie?
That'd be it, Judge. I appreciate it so much.
Okay, Mr. Edie, you're free to go. Mr. Parrish can go back.
Thank you, Judge.
All right, sir, have a good day. Okay, let's switch over to the lady side.
First one we have is Ms. Deeds.
I'm not the actual lawyer, so
Did you already hire her?
he's supposed to be,
All right, so we gonna stand by on Ms. Deeds. She advised that she had a lawyer, so he's supposed to be on first appearance.
Okay,
So
does she know the lawyer's name?
do you know the lawyer's name?
William, I don't know his last name though.
She says his first name is William. She don't know his last name.
Is it Arnold, William Arnold?
I think so.
That is, she says
Okay.
she thinks so.
Okay, we'll stand by for Mr. Arnold.
Okay, so Ms. Dunn.
Okay. Ms. Dunn, ma'am, you're charged with one count of simple battery. The bond is going to be set at $2,000. Do you believe you can post that bond?
You said $2,000, sir?
Yes, ma'am.
Yes, sir, I can post bond.
Okay, you're going to have a preliminary hearing date set for June 22nd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you
Yes.
like me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to hire your own lawyer?
I'll try to, sir.
Okay. Do you have any questions of me, ma'am?
You said my bond is $2,000?
Yes, ma'am.
So is that, like a cash bond or like the type of bond with 5 or 10% type bond?
Okay, so you're gonna have three options. One is cash. You can pay the entire amount in cash to the sheriff's department. They will return that money to you when your case is over. You can go through a bonding company. The bonding company is gonna charge you a fee. The fee is usually based upon a percentage of the bond. Whatever fee they charge, you will not get that money back.
Okay.
If you own property, you can real estate property like a home, or someone can put up their home. It has to have at least $6,000, $7,000 worth of equity in it. And if it does, they can put it up. There'll be a lien placed on the property. When your case is over, the lien will be taken off the property.
Yes, sir.
Okay?
Yes, sir.
Any other questions, ma'am?
No, sir.
Okay.
Thank you.
You're free to go back. Deputy Cox,
Yes, sir.
would you like me to give Mr. Arnold's office a call? I don't know if you need to go over to the other side or not.
If you wouldn't mind, sir, that'd be great. And once you call him, I ain't gonna tell you what to do, but once you call him, we can switch over to the mail side until he gets on.
Okay.
Just to keep it moving.
Yeah, I understand. Look, I can take advice.
Yes, sir.
Okay, give me 1 second.
Yes, sir.
Okay, I'm back. So, Mr. Arnold does not believe that Miss Dunn is his client. So what we're gonna do, we're gonna have to hold.
Miss D, you guys, it was D, not done?
Oh, Jesus, I did say, done. Give me 1 second.
Yes, sir.
Wait a minute, do I have a deed? Yes, sorry, I'm looking at done. See, that's what happens when you're not smart.
You're very smart, y'all. Smartest man I know.
Well, I wouldn't say that. Give me 1 more second again, I'm sorry.
Yes, sir.
Okay. So I verified with Mr. Arnold. He doesn't have anybody on today's calendar. So I'm not going to hold it against Miss D. I'm just going to switch over to the male side. And then by 11, whomever she's hired should be logging on. And
Okay.
we probably should be done. So on the male side, the fugitive that we have, we're going to save him to the end, and then we'll just cut through everybody else.
Ellison, come on up here.
Hey, Barker, advise them that this is still court and they can be held in contempt if they don't be quiet.
I got you, I just did.
Okay, let's start with Mr. Allison.
Judge, Mr. Ellison.
Mr. Allison, sir, you've been charged with 1 count of driving on an expired license and 1 count of driving on a suspended license. You're going to have a total bond set at $2,000. Do you believe you can post that bond, sir?
No.
Okay. You're gonna have a preliminary hearing date set for June 22nd at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, Mr. Allison. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No.
What's your question?
He said no, sir. No.
Oh, I'm sorry. Okay, Mr. Allison, you're free to go back.
Your Honor, Candy, Mr. Candy.
Okay. Mr. Candidate, sir, you've been charged with one count of family violence battery. The bond has been set at $3,000. Do you believe you can post that bond?
Judge, can you repeat, please?
Yes, the bond has been set at $3,000. Do you believe you can post that bond?
Yes, sir.
You're gonna have a stay away provision on this bond to stay away from Selena Kennedy. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 22nd at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah. Can you repeat that?
Do you want me to see if you qualify for the appointment of a lawyer?
No.
Okay, you're going to hire your own lawyer?
Yes, sir.
Okay. Do you have any questions of me, sir?
No, sir.
All right, you're free to go back.
Mr. Edwards, Your Honor.
Mr. Edwards, you're charged with one count of driving a vehicle with no license. The bond is automatically set at $1,000 for that. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for June 22nd at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Do you know how much you make per hour?
I mean, like $9 an hour.
Okay, you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back.
Voice, correct? Mr. Faust.
Okay, Mr. Faust, sir, you're charged with one count of simple battery family violence, one count of obstructing or hindering an emergency phone call, and one count of criminal trespass damage to property. You're gonna have a total bond set at $8,000. Do you believe you can post that bond?
Yes, sir. I just had to make a few phone calls.
Okay. Hold on one second, I'm sorry. There's gonna be a stay away provision on this bond for you to stay away from a Keosha Lane. Do you understand that?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for June 22nd at 8:30 in the morning, but that date is going to get waived upon your bonding out and you'll get a new court date in the mail. Do you have any questions of me?
Yes, sir, I do.
Okay, what's your question?
My question is, with the 8,000, could you explain to me why it's $8,000, sir?
Did you say, could I explain to you why?
Yes, sir.
Oh.
I don't understand it, sir, so I'm just trying to.
It's fine. You don't have to explain your questions. I'm here to answer your questions. So the simple battery, the bond for that is $3,000. The obstructing or hindering of emergency phone call, the bond for that is $2,000. The bond for the criminal trespass damage to property is $3,000. So that's how it added up to $8,000. Do you understand the charges? Do you want me to tell you the charges? like explain to you a little bit more?
Yes, sir, because when you say express that something was damaged, it was.
Okay, I'll tell you. Like I said, you don't have to tell me why you're asking the question. I'm here to answer. Okay, so the simple battery, the allegation is that I'm sorry, the obstruction or hindering the emergency phone call. The allegation is that Keosha Lane tried to make a phone call to 911 and that you took the phone from her and hid the phone. And this is alleged to have occurred on April 24th of this year. As it relates to give me one second. As it relates to the simple battery charge, the allegation again is that on April 24th, that you pushed Keosha Lane away from you and then held her down on the bed by her wrist and arms, and that she was able to break free, and that you began poking her harder with your finger at her throat, and she tried to defend herself with a fork. And that you fought to get the fork from her, and in the process broke one of her fingernails, and her fingernail began to bleed. And the fingernail broke off. And as it relates to the criminal trespass, damage to property, the allegation is again on April 24th, that you damaged her property by picking up a lamp and throwing it against the ground. And the value of the lamp was less than $50. So those are the three allegations that are against you, and they're all related to an alleged incident that took place on April 24th between you and Keosha Lane. Okay.
Yes, sir.
Do you have any other questions for me, Mr. Foss?
No, sir.
Okay, you're free to go back, sir.
All right. Your Honor, Mr. Hardy?
Okay. Mr. Hardy, you're charged with 1 count of trafficking marijuana and 3 counts of financial transaction card theft. I cannot set bond on this trafficking marijuana charge. And so I did not set bond on the other charges. I did set a preliminary hearing date for you for June 21st at 8:30 in the morning. I also set a bond hearing date for June 25th at 8:30 in the morning. Both of those at this point will be by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer? Did you say yes? Okay. All right. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay. You're free to go back.
Yes. Jefferson, correct? Your Honor, Jefferson?
Okay. Mr. Jefferson, you're charged with 1 count of theft by taking and 1 count of forgery in the first degree. I've set a total bond at $7,000. Do you believe you can post that bond?
No. He didn't hear you. He didn't hear you.
Okay. Do you believe you can post that bond?
No.
Okay. Your preliminary hearing date is going to be set for June 21st at 8:30 in the morning. That date will get waived if you're able to bond out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
How much do you make per hour?
15.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, you're free to go back.
Your Honor, Luan?
It's Luan? Sir, you're charged with one count of public indecency. The bond is automatically set at $2,000 for that. Do you believe you can post that bond?
No.
Okay. Your preliminary hearing date is going to get set for June 22nd at 8:30 in the morning. That date will get waived if you're able to bond out. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Morton. Morton. You're Morton? Come on. Come on. Kenneth Morton? Yes. Come on. Your Honor, Mr. Morton? Man.
Mr. Morton, you're charged with one count of family violence battery and one count of criminal trespass damage to property. You're gonna have a total bond set at $8,000. Do you believe you can post that bond?
No, sir. Can I ask you a question, please?
Give me a second and then I'll let you ask whatever question you want to ask. There's gonna be a stay away provision on this bond to stay away from Mary Morton. Do you understand that?
No, sir.
You don't?
No.
Okay. What is it that you don't understand?
I'm a caretaker, so I'm gonna stay away. I'm gonna stay away from that person. And it was just a misunderstanding. She was just mad. That's the reason why she called the police. But everything she said, it was out of anger, and she wanted to tell the people that I did not do nothing.
Okay. Would you like for me to appoint you a lawyer, Mr. Morton? And the reason I say that is because, like I said in the beginning, this is not a trial of your case. I can't like ask anybody else, is what Mr. Morton just told me true or false, or I can't sift through it or any of that kind of stuff. And I know that places you at a Mr. Morton, I know that places you at a disadvantage, but I can't, this warrant has been pending since November of last year.
I've been standing at 225 Johnson Road, Ford Park since last year or November. I ain't going nowhere.
Which has nothing to do with whether the warrant was pending or not.
Yeah, but
Okay.
So, Mr. Morton, I know you don't like what I'm saying to you.
Okay, can I ask you a question? Like the 8,000, I don't have no job, sir. I'm just, like, if it was 5 or less than 5, I could do that, but 8, I gotta get back home.
If she's living there, you can't go back home. And that's so, Mr. Morton, so you have to understand, you're meeting me for the first time. I'm meeting you for the first time. When we place these stay away provisions on, it's because we don't know you, we don't know her. This stuff can get changed, it can get fixed, it can get rectified. It sounds like from what you're telling me that you knew that she had called the police.
I was on the phone when the police was there. She told the police she don't want to press charges.
Which, that's not the right way to deal with it. Honestly, it's not. I'm sorry, but it's not. So, would you like for me to appoint you a lawyer that can get you out of this?
Yes, sir.
I'm sorry?
Yes, sir. Oh, no. Yes.
I'm talking about.
So is your job the caretaker of
Yes.
Miss Morton?
Yes, sir.
Okay. I'm going to appoint a lawyer to represent you, Mr. Morton, and you should be aware, and your lawyer probably will tell you, there are enhanced penalties as it relates to stuff like this for a person that's in your position. So if they were to believe these charges, they could upgrade these to felony charges and you could be facing serious time in prison.
Sir, y'all,
And,
It's-
and so, Mr. Morton, I'm not here to tell you that I think you did this or not, okay? I have to make decisions about bond based upon what I see here.
what you see there?
So the allegation, Mr. Morton, is that you, in a fit of rage, struck Miss Morton in the mouth and like broke a TV because you were throwing things around. That's the allegation. And the officer said they observed a cut on her lip. Okay.
If I struggle, you see how big I am. If I struggle,
We understand. This is a prelim. This is something that you got to speak with your lawyer about. The judges, he's trying to tell you that's all it is. He cannot change any of that.
sir, okay, can I say something, please?
Yes, Mr. Morton.
Okay, first, I would never strike that lady in the mouth because that lady is like very close to me. You know what I mean? Like very, very close to me. So I would never hit her in the mouth. You know what I mean? Like I said, she said that out of anger because she wanted me to leave her house. That's what it was. She wanted me to leave her house because when she called the police, I was there right with her. And I said, why did you tell them folks that? She said, well, you need to get out of my house.
So, Mr. Morton, all I can tell you is this. If what you just told me is accurate, you need to run away, because if she's going to make up stories whenever she gets angry at you, you're going to spend a lot of time in jail. And so wait, let me tell you, and this is, it's hard for people to hear sometimes, but the law enforcement officers, the judges, the prosecutors, everybody, we're not here to deal with these on again, off again things. I'm upset, so I said this, but then tomorrow I want to change it. No, it doesn't happen that way. And the system is not set up to encourage that. So if she really loves you and she really doesn't want you to be in jail, she should never say this again.
Yeah, but
If she, go ahead, sir. I'm sorry.
she been calling. She been calling now. She been calling now. Well, I ain't gonna say you, sir, but she been calling around to see how can she get these charges dropped. With everybody giving her the runaround.
You know what she can do? She can go to the police and she could admit that she made a false statement. That's a felony, and she can go to jail and you can get out. That's what she can do. Because that's what she did. She committed a crime. And if she's trying to, let me stop you. If she's trying to get out of not going to jail for the crime that she committed, you're going to stay in jail for the crime that she committed. It's hard. It is hard to hear. But this is not a game. There are people in this county that need the services of police. They don't need to go play with people that want to dial 911 to solve their problems. So you have to understand that. And it has to, I'm sorry for you, sir, that you're dealing with this, but you have to let this soak in, that this is not a game. She can't just pick up the phone and call 911. You can also make a report that she made a false statement against you, a false report of a crime, and you can be the victim, and she can be the person that goes to jail.
Man, I'm not gonna send my mother to jail. That's one thing.
Okay. Okay. So we're all clear. You got the lawyer. You tell the lawyer what happened, and the lawyer will talk to the solicitor about it. Okay.
So how can I get a speedy trial?
Talk to the lawyer. You haven't even been accused yet. You can plead guilty on Monday if you talk to the lawyer. And if you're guilty, if you want a trial, you can ask for a speedy trial. Things are backed up. You'll have a trial sometime later this summer. Okay? All right, you're free to go back, Mr. Morton.
Mr. Marshall?
Mr. Marshall, sir, you are charged with criminal damage to property in the second degree, cruelty to children in the third degree, fleeing from a police officer, reckless driving, hit and run, and obstructing an officer. I cannot set bond on the criminal damage to property in the second degree charge. It's a felony offense, and there's an indication that you are still on probation. I've set a $5,000 bond on the cruelty to children. I've set a $2,000 bond on the fleeing from a police officer,
Keep going.
a $2,000 bond on the reckless driving, a $2,000 bond on the hit and run, and a $2,000 bond on the obstructing of an officer. I've set a bond hearing date for June 25th at 8:30 in the morning. I've set a preliminary hearing date for June 21st at 8:30 in the morning. Currently, both of those hearings will be held by Zoom. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
So basically, I don't have a bond. It's a preliminary.
No, sir. No, sir.
So what is my court date?
June 21st and for the preliminary hearing, and June 25th for the bond hearing. I've appointed you a lawyer. The lawyer may be able to get you a hearing sooner. As I indicated, it's showing that you're still on probation, so I cannot set a bond at this time on that felony offense. But the prosecutor, your lawyer may be able to speak to the prosecutor, and they may be able to reach a consent as it relates to your bond.
So I have my family trying to get me an attorney. Will they be able to get in touch with probation and see if they will still be able to set me a bond?
Yes, and it's not probation. You're being held because of the fact that you're on probation. But generally speaking, if they'll contact the probation officer and the probation officer says, oh, no, he's fine, he does what he needs to do, I'm not concerned about him getting a bond, then they may consent to a bond.
But I'm currently on non-report. Who do I contact?
The probation office.
Your lawyer's gonna contact your office, okay? Once you get done here, your lawyer's gonna handle all that, okay? You get in contact with your lawyer at that point in time, contact that. We're trying to keep it moving.
Okay, so from there, they'll give me another bond hearing before the 20th?
Yes, sir. Yes, sir. But you'll have to talk to your lawyer about all of that stuff, because I'm just speculating.
All right?
Okay, you're free to go back, sir.
Mr. Nugent?
Okay, you are Jerry Wynn. Sir, you're charged with 1 count of theft by taking motor vehicle, 1 count of theft by taking, and 1 count of driving on a suspended license. It's also showing that you're on probation, so I can't set bond on the 2 felony offenses. For the driving on a suspended license charge, you have a bond set at $2,000. There's going to be a preliminary hearing date set for June 21st at 8:30 in the morning. There's going to be a bond hearing date set for June 25th at 8:30 in the morning. Currently, both of those are being held by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
No, yeah. It's that's so easy, mom, you got to talk to the lawyer. He doesn't do that.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
How much was my bond? I understand that, but I'm done.
You do not have a bond set on the 2 felony offenses because it was showing that you're still on probation. And I can't set a bond at this hearing for anyone who's charged with a new felony offense and they're on probation.
Alright, thank you.
Okay? Any other questions?
Who will I be going to court?
I'm sorry.
Who will I be going to court?
June 21st is the next preliminary hearing date that's set. Because of these COVID times, things are being set further out. So depending on your lawyer and what your lawyer and you decide, you may be able to get into court sooner.
Okay, thank you.
Okay, free to go back.
Mr. Polo? How you doing?
Mr. Pope, you're charged with 1 count of robbery, 1 count of battery against a pregnant female, and 1 count of criminal trespass, damage to property. Bond is going to be denied on the robbery charge. At this point, I'm setting a $5,000 bond on the battery, and I'm setting a $3,000 bond on the criminal damage to property. You're going to have a preliminary hearing date set for June 21st at 8:30 in the morning. You're going to have a bond hearing date set for June 25th at 8:30 in the morning. Currently, both of those hearings are being held by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir, I have questions. Can you read me my allegation?
Yes, give me 1 second. Okay, you do qualify. I'm going to appoint a lawyer to represent you. So these are warrants that were taken out, and they were taken out on March 28th. And the allegation is that on March 28th, I'm sorry. There's also a stay away provision on the bond, stay away from a LaAsia Lackey. So the allegation is that you and Miss Lackey were in an argument, and that you went through her cell phone and apparently got angry with her about something that was in the cell phone, and that you and her argued, and you left and returned and want to talk about the incident. She says she refused to open the door, that you damaged the screen to her window in order to open the window.
Is that what makes my charge robbery?
Yes, saying that the snatching of the iPhone.
Your Honor, I had the phone already. You know, it says it in the thing that I have.
Again, the judge is here.
I understand.
He's not here to change the charge.
So Mr. Pope, as it relates to anything that happened with this case, you really need to talk to your lawyer about it.
I'm asking for you to talk to your chief about the robbery as a signature bond, because I don't feel like I need that charge. So I'm asking if you can do that, that's fine, because I never robbed my girlfriend and my baby.
Okay, so you're not going from a no bond to an OR bond. And the OR bond, if I recall, hold on, let me take a look.
I have robbery, sir. Robbery.
I did not make the charge. Mr. Kendrick, how are you?
Good morning, Your Honor.
You are representing Ms. Deed?
That's correct, Your Honor.
Okay, give me 1 second.
Thank you, sir.
Okay, Mr. Pope. Yeah.
He at least take
He can't take any charges off. I'm not gonna tell you again.
Mr. Pope, so you know you're charged with burglary in August of 2019 in DeKalb County.
I was charged again.
No, you say what your charges were. You had these charges before.
2019.
Yeah, they supposed to be like 2017. I was a minor when I had those charges.
Okay, so Mr. Pope,
I understand what you're saying, but I don't.
All right, stop.
so Mr. Pope, you really need to talk to your lawyer about these charges. You really do, Mr. Pope. You're not going to change my mind. And you're only going to make your situation worse.
Right.
Like, I don't know what's going on.
So anything else, Mr. Pope?
Okay, you gonna point
Who's
me out.
William Kendrick?
Yeah.
Yeah, he's on.
He's on Deputy Cox, so you can bring up Miss Deed. Mr. Pope, you're free to go back.
You gonna appoint me a lawyer?
Mr. Tony. Oh, wait, hold up.
Now you can. Ms. D.
Mr. Kendrick, your client, well, first, Miss D, I would normally address you directly, but you have a lawyer here, Mr. Kendrick, so I'm going to speak to him about your case. You should understand that anything you say here can be heard by anybody and it's not privileged. So please don't say anything that you don't want the whole world to know, okay?
Okay.
Okay, Mr. Kendrick, Ms. Deed is charged with aggravated assault with a deadly weapon, aggravated battery, and family violence battery. And I've denied bond on the aggravated assault and aggravated battery based upon it appears that she is on probation. I've set a $5,000 bond on the family violence battery, and I've placed a stay away provision on this bond to stay away from a Raynisha Williams. But I will hear from you as it relates to anything you want to say about your client. And I'm scrolling back to her criminal history. So
Yes, sir, Your Honor. I was unaware. I did speak to Mrs. Deed about or any prior criminal contact, but I did not have the information that she was on any type of probation. However, Your Honor, I have been in contact with Mrs. Renisha Williams. This is her roommate, and basically, Your Honor, they had a night where they were out and partying and got into an altercation with some other women. Outside of their altercation, they got separated, and so when they got back together, they were upset, and got into an altercation there in the car. Mrs. Williams, I have by text message and as an officer of the court, I can state she does not want to go forward with the charges. She does not want Mrs. D to be held without bond. She does want her to be released and be able to continue to work. She's been on her job for a period of years, Your Honor, and has a home as well there in that area. And so I'm venturing, of course, to ask the court with that being said, to set bonds on those other charges, maybe in the amounts of 5,000 each on each count. I know that is also in line with what she's already got on the misdemeanor charge. But Your Honor, also I understand that this is basically just dealing with a cut. It's not a firearm incident. So I think the allegation is that the weapon would be a knife or something along those lines. As I understand, after we really fleshed out the situation, Mrs. Williams realized that a lot of the injuries that she received were from the previous fight with the other group of girls. And when Mrs. Deed and Mrs. Williams rode home, they were arguing and fussing about being separated, and that's something that they said that they weren't going to do when they go out and have a time there together. So they're not in any relationship. Your Honor, it's not that type of scenario, and just asking the court to please set reasonable bonds, given that explanation. And I have Mrs. Williams on standby if the court needs to hear from her in that regard. But I have communicated with her as early as or as late as a couple of minutes ago via text message, and she said she would be available for whatever.
She's from, so to the extent that she does not intend to pursue this, that's going to have to be a discussion with the district attorney's office. Your client is a multi-state offender out of looks like Washington State and Sacramento or Stockton, and I believe that's where the probation looks like that's where she's on probation from. So Miss Williams could be here saying, I don't want to prosecute, and I still can't do anything as it relates to that because of 17.1. Now, it doesn't mean tomorrow the district attorney can't agree to all of this stuff. I just can't do it based upon the charges and the statute.
Your Honor, can the court enlighten me as to the charges and what is she on probation for?
Okay, it appears there's a battery that looks like she was arrested in 2019. And she was placed on 3 years probation, 60 days in jail. And there are, it looks like 12 cycles out of California.
And so that's this felony probation?
No, it's not. So under 1710.1, if you're on probation and you're charged with a new felony or a misdemeanor that's considered a crime of violence, the judge at first appearance can't set bond.
Cannot set.
And that's just because, you're arrested at night, you go before a judge in the morning, you get a bond, you're gone. And then probation says, hey, we didn't want her out. So that's where that law came from. So the way that it's written, it says upon a hearing, which could be between you and the district attorney, not, and y'all reach an agreement and then the judge signs off on it. So that's what I say. It's not today, I can't do it, but tomorrow doesn't mean somebody else, you and the prosecutor can't reach an agreement.
Understood. I see my client raising her hand. I think she knows about the cautionary statements. I would ask to hear from her very briefly.
Yeah. So I'll say, Ms. D, generally what people normally say is, I'm not on probation anymore, or that was taken care of, or whatever. And I have to say that all of that may be true. I have to go upon what I'm looking here. And so that's why I tell people, because these documents can be wrong, but I don't know you. And so I can't just accept you're telling me probation is taken care of. If there's a document that I have in front of me from a probation officer or whatever saying it's resolved, I can rely upon that. But I can't just rely upon what you tell me today.
Okay, so the only thing
Wait,
that
Mr. Kendrick, are you still there?
Yes, I'm still here, Your Honor. Yes.
Okay, so Miss D, I really want to caution you, because I've had people, I'm not going to talk about my case, and they say, well, yeah, I did this, but I didn't do that. And it's like, you just admitted to a crime. So that's why I gave you that information, ma'am, so that you know that there's absolutely nothing you can tell me that's going to change my mind.
I was not gonna, I wasn't trying to change your mind. What I was trying to explain to both of you guys is that I was on 3 years in formal probation. When I went to court in California in January 14, to take care of the warrant that I had out there. My 3 years was already taken care of. I'm not on 3 years probation no more. So I was just trying to let you know that how would I be able to prove that being in here? Is that something that my lawyer can reach out to California to find out, or?
You should have received documentation, ma'am,
I
that you
have it at home inside my purse.
give that documentation to your lawyer. And that's why I explained this to, so, okay. So the reason I explain my reasoning to people so that if there's a mistake or there's anything wrong, it can get rectified and you know what you have to do. So I understand that you're in jail. I can't release you to go get the paperwork because if that's the case, I've already put you on bond. Does that make sense to you?
Mhm.
So talk to your lawyer and you should be able to work it out.
And Your Honor, and the only other question that I would ask is, can you, I'm looking at 1761 now. In
1710
regards
one.
to
1710
one. Okay. And basically, it's just because she's on probation that there with magistrate court that it is she's just not bailable in front of Your Honor.
Exactly.
I'm just looking for that code section. I see it, Your Honor. Subsection B.
Yes.
Of that code section does not authorize state or magistrate court to grant bond when a person is on probation. Tracking, Your Honor, tracking. And I did not have that information before here today, and so I would have planned a little bit better if I had known that you're still on active probation. Your Honor, I thank the court.
And and I, like I said, I say that to people because if I'm wrong, that's something you can point out to the district attorney and say, hey, that was the basis for it.
Understood.
She's going to have right now a bond hearing date set for June 25th at 8:30 in the morning, and a preliminary hearing date set for June 21st at 8:30 in the morning. Both of those currently are going to be by Zoom. Because of how things are going with the COVID stuff, the district attorney's office, my understanding is working cases, bond cases or people in jail. They're working those cases and working through those cases to get people out because of the COVID related stuff.
Yes,
so
that's my next call. I'll be calling to the DA's office to find someone to speak to about this.
All right. Is there anything else, Mr. Kendrick?
No, Your Honor. I thank the court for its time and for your edification and instruction. Thank you.
Okay. Thank you, sir. You're free to go. Ms. Deed, your lawyer's gonna be in contact with you, and he's gonna be in contact with the district attorney's office.
Okay, thank you.
Okay. You're free to go back. All right, let's switch back over to the mail side.
Your Honor, Mr. Tony.
Okay. Mr. Tony, sir, you're charged with 1 count of family violence battery and 1 count of criminal trespass. You're going to have a total bond set at $8,000. Do you believe you can post that bond, sir?
Yes, eventually, yes, sir.
Okay, you're going to have a preliminary hearing date set for June 22nd at 8:30 in the morning. That date will be waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back.
He's got one question.
Yes, sir.
Would there be any conditions of the bond or whatever?
Yes, thank you. I'm sorry. There's going to be a stay away provision on the bond to stay away from Rhonda Tony.
Okay, that's where I have a question. Okay, we are married and we live together, and I am the head of the household. I was talking about on taxes and everything. How do we manage that?
Well, so currently you are the accused and she's the victim. And because of that, we place stay away provisions on the accused to stay away from the victim.
Okay.
And the victim can ask the solicitor to change those conditions or whatever. We don't get into that. So until that condition is changed, if you were to go around her, you can get aggravated stalking charges and your bond will be revoked and you will be held without bond. Now, the allegation is that on April 27th, you punched her in the face and head with a closed fist. If those allegations are false, it would not be in your best interest to be around her. Because if those allegations are false, that means she made a false allegation to get you arrested.
Okay.
Yes, sir?
I make no claim.
Nope. And I don't want you to. And I'm not asking you to make any claim. Okay.
I'm just trying to get an understanding. So, because see, another question is, I noticed on the paper that it said the victim could not bond you out.
Right.
Okay. All of the rest of my family live in Alabama. I live in Georgia with my wife. My wife has walked to this very facility from her residence in order to try to not proceed with these charges. And so if I propose bond, she is likely going to be the only person that is going to come get me, because it will be her, it won't be anybody. So that she is most definitely going to come get me from me. So I'm trying to see who do she need to go work to get one of her friends, maybe the lawyer. Since I ain't trying to make no deception or anything else, but now she gonna be trying to come get me.
So, Mr. Tony, if she were to come up here and you were to be around her, that could subject you to going right back into the jail before you get off the property. Okay. Okay. So, anything else, Mr. Tony?
He said no, sir. No, sir.
Okay, you're free to go back, sir.
Mr. Thornton.
Mr. Thornton, you're charged with one count of carrying a weapon concealed without a license. This is a misdemeanor. The bond is automatically set for this. It's $5,000, but it's going to be a little bit higher because the Sheriff's Department is required by law to add fees to your bond. Do you believe you can post this bond?
Yes.
You're going to have a preliminary hearing date set for June 22nd at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions of me, sir?
Can I get the bond reduced, man?
It's set by schedule, which means it's automatically set. It means a group of judges sat around and figured out what was the appropriate bond for this offense. So it's going to stay there.
So one other question. When I do get my weapon back, can I just keep my weapon on me with invisible sight? I'm still.
So go to the probate court's website and it gives you all of the stuff as it relates to carrying a gun. I'm not going to be in a position where Judge Gardner told me I could do this. Okay. So go to the probate court's website and you'll learn all about what it means to open carry and what it means to carry conceal.
Okay.
Okay. All right, sir. You're free to go back.
Mr. Wood.
You're Mr. Wooten?
Yes, sir.
Okay, sir, you're charged with 4 felony offenses, and there's an indication that you are on probation, so I was not allowed to post bond on these offenses. I am setting a preliminary hearing date for June 21st at 8:30 in the morning. I'm also setting a bond hearing date for June 21st at 8:30 in the morning. Currently, both of those hearings are being held by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
I have a lawyer.
Okay. Do you have any questions for me, sir?
You, read the allegations.
Yes. So there are 4 felony drug charges. One is possession with intent to distribute marijuana. And the allegation is that on May 3rd, during the execution of a search warrant at 6711 Church Street, that they found 4.18 ounces of marijuana, 27 white rectangular bars of Xanax were located in a residence in a room that was allegedly occupied by you and a Keith Chambers. A .380 Glock handgun and a .40 caliber Glock handgun and rifle were also located in the bedroom. And it said that it was occupied by you and Mr. Chambers. It says a scale commonly used to measure narcotics was located in the room, along with several empty plastic bags with green leafy substance residue throughout, consistent with debris from marijuana and individual packaging.
All right, can I say something, Lou?
Yes, but be careful because anything you say is being broadcast on the internet.
When they came, they had a fugitive warrant for me, and they came and got me. So when they first came and got me, all I had was a VOP charge, and they already took me to the Plain County. Then they had a search warrant because when I heard it, they smelled marijuana. All right, they had a search warrant. They searched the house. That's not my room. I know you're not the judge to say it, but somebody claimed everything in there. I didn't claim nothing. He claimed it in this verified. He claimed every gun, and the guns are in his name. So I don't understand how I am charged with everything that is he claimed. I didn't claim nothing.
So these are allegations. The state has to prove these allegations beyond a reasonable doubt. The fact that you are alleged to have done something doesn't mean that you did it. But law enforcement can charge whomever they want to charge based upon what they believe. They're the ones that are going to have to take the stand and back it up.
Yes, sir.
Okay. Anything else?
No, sir. Thank you.
Okay, you're free to go back.
Lastly, we have Mason, Your Honor.
Okay.
Fugitive.
Mr. Mason, sir, you are all of the rights that I read before still apply to you, but you're in a separate situation in that there's an allegation that you are a fugitive from Baltimore County, Maryland. So you're not being held here because of any allegation that you committed a crime in Clayton County. You're being held because Baltimore County has a warrant for your arrest, and they've indicated to the sheriff's department here that they want to extradite you. You have a right to contest that extradition, which means you have a right to say, I want a hearing to make sure that A, y'all have the right person, and B, the allegation that you have against me is something that is actually a true charge. And the warrant is for some kind of fraud allegation or charge in Baltimore County. If you were to say, I want to have that hearing, then we will reset your case, put you on a calendar within the next 30 days. And at that hearing, the judge will inquire and look into the warrant, and the judge will look into and see that you are the person named. If those two conditions are met, the judge will sign off on your being sent back to Maryland, and then Maryland will have up to 60 days to come and get you. If at the end of that period of time they do not come and get you, The sheriff's office here will contact Maryland and say, hey, you guys said you're going to come and get him. And if not, then they will release you out the front door. That doesn't mean the warrant was dismissed. So you could go to the bus station. 5 minutes later, you can encounter law enforcement. They run you. They see that you have a warrant for your arrest, and you go right back to jail. You also can waive that process, and you can say, I do believe they have the right person named. I do believe that there is a warrant for my arrest there. If you were to waive that process, the clock starts to tick today. And so essentially all you're doing is buying yourself an extra bit of time. Well, you're moving the process along faster. And that's what I mean by buying yourself an extra bit of time, or you're cutting time, actually, is the correct way to say it. Do you have a lawyer representing you in the charges up in Baltimore?
I'm confused. Well, can I say something?
Yes, sir.
I was kind of confused because I don't go to Baltimore and I'm from Virginia. And when they got me from like the airport. And first, can I ask when will these charges placed on me? Like when?
I don't have that information. What I have before me is that I have the warrant number, which is D190576050. And so what it says is that you are wanted by Baltimore County Police Department, Townsend, Maryland. So I don't know. And when you say, look, I don't know. So that's where this whole process starts, where if you think that, hey, I'm not that person, I was never there, then that's something that will get dealt with up there, not down here. Because here is only if you're the person named. So let's say that the person in the warrant is John Smith, and I'm John A. Smith. And so I was like, I'm John A. Smith. I'm not John Smith. My birthday, I was born in 1974. I wasn't born in 1984. So then it's like, oh, okay, well, hey, maybe this is not the right person that's named. But, you know, that kind of, the question that you ask is sort of a searching question for answers. And I'm telling you, I don't have the answers. The answers will be had up in Maryland. If you believe that this is something that is bogus and never happened, your best course is to hire a lawyer up in Maryland to go and say, show me this stuff. Okay. We can't fight it from down here.
So how do you know how long it would take them to come get me from you?
I do not. They have an initial 30-day period, and it could be up to 60 days. Sometimes they move faster, sometimes they move slower. Because I'm not the person either buying the plane ticket or putting the key in the car, I can't tell you. So, do you have any other questions about this process? Have you thought about this process?
I just want to do it the fastest way that I'll be going back. And the best way is for them to come get me there. I'd rather than just come on with it.
Well, the method that takes the least amount of time is to waive the hearing today. I will sign the documents, and the clock will start ticking today.
Mm-hmm. So that's what I'm basically come get me.
I'm sorry, say that again.
That's for them to come get me, right? Like if I waive the hearing, that's for them to just come off. So it can start ticking and then come get me.
Yes, if you were to waive the hearing today, then they will get a call today that they need to come get you. If you were to ask for the hearing to make sure that you are the right person named and the charges are valid, after that hearing, they will get a phone call to come and get you. Okay.
I'd rather waive it so it can be faster.
Okay, so there should be documentation there for you to sign You're gonna sign the documentation, and then they're gonna send it over to me, and then I'll sign it and I'll send it back with the paperwork that goes back today.
It's signed, Judge.
Yeah.
Okay, anything else, Mr. Mason? No. I think you froze. I think you froze. Could you repeat that?
You can hear me?
I can hear you now.
Oh, I say, yeah, that's it.
Okay, you're free to go back. Have a good day, sir.
Just step over there. Step over there. That's it, y'all.
Thank you for